Any questions or discussion?
Madam Chair, I move that the commission accept and adopt the recommendations of the executive director to enter a default final order to revoke the license of Renee Ramirez.
We have a motion and a second. All those in favor say aye. Aye. Any opposed? Same sign. Motion passes. Mr. Winter.
Commissioners, the next individual before you is David R. Garcia. Mr. Garcia received deferred adjudication for a Class A misdemeanor of interfering with an emergency call. He entered into negotiations with executive director staff and has agreed to the order that would revoke his license. And so the executive director recommends the commission accept and enter into the order that is agreed to by Mr. Garcia for revocation of his license.
Questions or discussion?
Madam Chair, I make a motion that we accept and adopt the recommendations of the executive director to enter a final agreed revocation waiver for David Garcia.
We have a motion and a second. All those in favor say aye. Aye. Any opposed? Same sign. Motion passes.
Commissioners, the next individuals will like to take up as a group. They are William M. Ennis, Courtney D. Fountain, Marco A. Herrera Jr., Jacob T. Trujillo, Tiffany P. Yan, and Curtis A. Webb. All of these individuals were with the Parker County Sheriff's Office and were involved in a situation where collectively they caused to be submitted false or untruthful training reports. Discussions with the executive director staff, they have agreed to accept 14-day suspensions. They've negotiated resolution with the executive director staff, and we do recommend that the commission enter into and accept these agreed suspension orders for the individuals that I just mentioned.
Questions or discussion?
Madam Chair, I make a motion that we accept and adopt the recommendations of the executive director to enter a final agreed suspension waiver for William Ennis through Curtis Webb in our packet.
Have a motion and a second. All those in favor say aye.
Aye.
Any opposed? Same sign. Motion passes.
Commissioner, the next individual before you is Daniel L. Beckman, peace officer who was convicted of the offense of driving while intoxicated. After negotiation, he has agreed to a 10-year suspension. After negotiation with the executive director, he has agreed to the terms of a proposed order that would suspend his license from June 28, 2021 through October 28, 2022, followed by a period of probated suspension for 8 years and 8 months.
Any questions or comments?
Madam Chair, I make a motion that we accept and adopt the recommendations of the executive director to enter a final agreed suspension order for Daniel Beckman.
Second. We have a motion and a second. All those in favor, say aye.
Aye.
Any opposed, same sign. Motion passes.
Commissioners, the next individual is Gabriel Lechuga with the El Paso Police Department. Mr. Lechuga was convicted of a alcohol-involved driving offense out of state. After negotiation with the executive director staff, he has agreed to a order that would suspend his license for 4 years. In this situation, it would be fully probated, backdated to January 11, 2018. The executive director does recommend entry of an approval of this.
Questions or comments?
Madam Chair, I make a motion that we accept and adopt the recommendations of the executive director to enter a final agreed suspension order for Gabriel Lechuga.
We have a motion and a second. All those in favor say aye.
Aye.
Any opposed, same sign.
Commissioners, I'm understood you had a hard time hearing me before. I hope you can hear me now. The next individual on your agenda is Curtis T. Harris. Mr. Harris is the elected constable of Smith County, Texas, and he was arrested and charged with a felony offense. And this is a situation where, under the authority of the commission laws of the state of Texas, we entered into a summary suspension of his license pending resolution of the felony charges. Mr. Harris, Constable Harris, contested the implementation of the summary suspension. It went to the State Office of Administrative Hearings, where my staff represented the executive director, and we prevailed. There is a proposal for decision issued by the administrative law judge upholding the summary suspension of Constable Harris pending resolution of the felony charges. It's the first time I believe that we've had one of these that actually went to a contested case hearing at SOA, and we're pleased to present this here today and ask that the commission approve the proposal for decision issued by the State Office of Administrative Hearings.
Questions or comments?
Madam Chair, I make a motion that we accept the proposal for decision to suspend the license of Curtis Harris during the pendency of his criminal proceedings.
We have a motion and a second. All those in favor say aye.
Aye.
Anyone opposed, same sign. Motion passes. Mr. Winter?
Commissioners, the final individual before you for action today is Bruce A. Hoff, peace officer. The executive director brought proceedings against him for a third time noncompliance with his continuing education requirements. Mr. Hoff answered the petition and requested an administrative hearing. We moved for a summary disposition based upon the uncontested factual record, and Mr. Hoff failed to respond to the motion for summary disposition. The administrative law judge then has consequently issued a proposal for decision recommending that Mr. Hoff's license be revoked. The executive director concurs with the proposal for decision and does recommend revocation of the license. I believe Mr. Hoff is here, and I believe he may wish to address the commission.
Please come up, sir, and if you'll introduce yourself, and then make whatever comments to the commission that you would like us to know.
Good morning. My name is Bruce Huff. I'm retired sheriff, Menard County. I have a master's peace officer's license, and sheriff for 12 years, constable for 4 years, elected official for 16 years. I haven't been on the street in over 10 years. So I run a lumber yard. I'm a volunteer firefighter and have been for 34 years. And really, I don't have any, leg to stand on. I didn't report my training. The only thing that I have, to argue for myself is every year, I get training through fire department, through my company, and I ask for help in reporting this training, and I get no help either through my agency I'm licensed from or from a field officer that I contacted in the past. I understand that I've violated the rules. If the rules are for kick people like me out, then kick me out, But I haven't violated any laws, never been arrested. I'm a very, been a member of my community for 50 years, very responsible, have a successful business that I run. And, that's about, all. If y'all have any questions, I'll be glad to answer them. But the problem I have is, I went to my agency and I do this training. How do I send this in? Because when I was constable, I used to turn in my own training, And I don't know if they did away with that or what, but I think the lady's not telling me the truth and said, you know, we don't have any mechanism to report that training anymore, and I don't think she's telling me the truth.
Questions from the commissioners?
Now, y'all, if y'all have any discretion you know, in this, and evidently y'all do, y'all gave some discretion to this fine young man here to let him get his license. You know, there's no reason to revoke my license, you know, other than administrative reasons. They said I had a right to have a hearing, and then I get all this lawyer stuff. I could have hired an attorney for $10,000, but I mean, I don't make my living doing as a peace officer. I may go back to it one of these days, and that's the reason I want to keep it. So I guess I'll just leave it up to y'all's discretion. Don't know if y'all have any discretion in this.
Winner?
Yes, ma'am.
Any further comments?
No further comments at this time. I'm happy to answer any questions that the commission may have.
I want to speak on the matter of discretion in this matter. When this commission amended this rule relating to continuing education, I don't know off the top of my head when it was done, but it's been within the last 2 years. It was very clear as communicated to staff that 3 continuing education, missing education for 3 times was going to be a mandatory revocation. Staff has taken the commission's wishes in relation to that, passed a rule, and then followed that as applied to the facts, particularly in this case, sent to the Attorney General's office, and we've submitted a motion for summary disposition. As far as there being discretion as to this being a suspension or not, I know the commission was very clear when this rule was passed. Shall be revoked when there have been 3 continuing education reprimands, suspensions, whatever the case is. However, the only option that I can see, if we're talking about options today, as far as action on the proposal for decision, there is no discretion. It's a shall revoke the license. However, if Mr. Huff wants to surrender his license in lieu of it being revoked, that would be certainly something he could exercise. But as far as the commission goes, I think unless Mr. Winter has another opinion than that, and I'm certainly open to it, I don't think we have much discretion in relation to the facts applied to this case.
I concur with Mr. Beecham.
Any questions or comments from the commissioners?
Well, I didn't bring any actually transcripts of, you know, only piece of evidence I have is I have an email that I sent to a field agent in 2018 asking him to, you know, please help me report, you know, my training for this period. I didn't get any response. I left a message on his phone, you know, and he didn't call me back.
Commissioners, I'm sorry, I didn't mean to. If you also have the option, if we want to leave the record open, you don't have to take action on this proposal for decision day, and we can leave the evidentiary record open as to if there's anything that could be presented that in any way would mitigate any of the notice requirements that have been observed, or if you want consideration as to whether or not the licensee could report, wasn't allowed to report. Obviously, executive staff can respond as to availability of training, and certainly their input would be welcome here as well. I'm just leaving that as an option as well.
Madam Chair, I can offer some explanation on kind of the situation that he's in. If he's not currently appointed, then a department can't report him.
Yeah,
unless
I have
they.
an appointment.
You currently have an appointment?
Yes, I'm a deputy of Menard County.
Where are you appointed?
Menard County.
They wouldn't report your training.
She told me she didn't have any mechanism. She doesn't want me to have a peace officer license. If I was her boss, she wouldn't have a job.
I do have a comment.
Did
to make.
they take that mechanism away where your agency can report
Sir.
just generic hours?
Sir,
I'm sorry.
I do have a comment to make. I think if the commission feels uncomfortable about making a decision today, as Mr. Beecham stated, we can leave it open and bring it back to the next meeting. With all that said, there was a mechanism for Mr. Huff to use, and that was at the SOA hearing. He was given every opportunity, just like everyone else is, to present mitigating evidence at that hearing.
I didn't
So
have
whether
hearing.
he chose to have a representative or not, he's allowed to bring in anything. And truth be told, just because you have a lawyer at a hearing like this doesn't mean necessarily that you're going to be excluded or treated badly because you don't have a representative and you're there pro se. I find in practice it's actually the opposite. A judge is going to give every opportunity to an individual representing himself to present evidence in any way that he can and speak, whether following rules of evidence or not. That has been my experience for years and years. I don't see how that would be any different in this administrative hearing. So, again, Mr. F has had the opportunity to do these things. We are an institution that is about following rules and laws that are given to us by the legislature, that are implemented by us, and some promulgated by us. And if this is a rule that we chose to have for a reason, I think it's incumbent on us to follow the rules that we have set.
Commissioner Burris, just one point of clarification. We did file a motion for summary disposition to resolve this, analogous to a motion for summary judgment, and Mr. Huff failed to respond to the motion for summary disposition. So this is in effect a default, and there was never a actual contested case hearing convened with the taking of evidence. The judge ruled on the law and what was presented in our motion for summary disposition.
But he could have presented the statements that he's talking about, whether in writing,
Yes.
whether it be a sworn statement or otherwise, for some sort of consideration to the administrative law judge.
Yes, sir, that's correct. He failed to respond to the motion for summary disposition. The administrative law judge, when the time had expired, allowed under the law for a response, issued an order granting the motion for summary disposition. Then additional time passed, and the administrative law judge issued her final proposal for decision. There were multiple opportunities for Mr. Huff to have responded. He could have responded to our motion for summary disposition. He did not. He could have responded to the administrative law judge's initial order announcing that the time had expired for a response. He could have come back in and said, oops, I'm sorry, I'm late. He did not. He also could have filed exceptions to the proposal for decision when it was issued in December of last year. And again, he did not.
And you could have brought information here today, and it could have been remedied in 2015, in 2020, all the prior dates. So, I mean, I understand. I think your actions, Mr. Huff, have been that you don't actually intend to use this license. I mean, sounds like you've got a great career, and you've got your lumberyard and all these other things, your volunteer work, and that's all great. And I don't want to take anything away from you and everything that you're doing. I just think your actions versus your words are that this isn't really something that you really need in life going forward, or you would have scrambled and done all these things. And I think that's perfectly fine, too, to say, you know what, I'm thinking about it, and I don't really need to hang on to this license and go out of my way to take training that I have to pay for and do all these things. And I think that's, you know, we all have to, we all reach a point where it's, you know, it's time to move on and concentrate on other things. So I appreciate you coming and speaking.
Thank you for your comments. But the reason I'm here is when I first got this letter, I had 3 violations. You have a right to have a hearing, and I requested a hearing. I didn't even know this other stuff was going on with the Attorney General's office. I didn't get a notice that, hey, we're having this happening. I got the stuff afterwards, which I don't understand I thought it was a done deal. Then when I get a chance to come and plead my case at a deal like this is when I'm gonna come plead my case. If y'all have to make a decision, do it. If you can put it off, and, you know, I would prefer you to put it off.
Commissioner Hester.
What,
Thank you.
so, one second. So you made a comment a while ago that you don't have any evidence to present to refute the training hours, right? I heard you say that. It was kind
Right.
of quick, so.
I didn't bring any transcripts of classes and stuff with me, no.
Okay. So, and then when you were issued the 3 notices that you didn't do your training, we always give you an opportunity to report your stuff or provide stuff to the staff. So did you do any of that?
Well,
when you got that
I
letter?
tried. That's what I reached out to my field officer. Hey, how do I report this training that I've had the last 2 years? And I didn't get any help over three cycles. I didn't get any help from my licensing agency or my field officer at the time.
I want to talk about, so you sent an email to the field service agent in 2018?
Yes,
Is that the last time you sent an email?
yes.
Okay.
And also called and left you a message. Well, and I've been talking to Liz at y'all's office, who I've been talking to the last couple of years.
So help me understand, you said you attended training. The rule speaks to what type of training is acceptable. So can you explain what type of training that you got?
I go to pipeline safety training almost every year, and it's for first responders. I go to weather watch training almost every year for, first responders. My company gives training like reasonable suspicion training, for drug testing. It's a DOT class, taken that a few times. I mean, any type of leadership classes or management classes that my company puts on would qualify as better than some law enforcement training that I've been to. Any of that, since I'm a master peace officer, any of that generic training would qualify.
Well, I don't know
Any
that I
specific
necessarily agree
training-
with that statement at all. You
What's
have
that?
to show a correlation to your job duties. I can't go take basket weaving and turn it in.
Right,
and get
right,
credit.
no. We get so much continuing education in my company, not all of it qualifies. If it's management trainee, management training or, software that, cyber attack training, hey, I think that's training that works for law enforcement also, something like that. I wouldn't report anything that wouldn't benefit, law enforcement.
Commissioners, if I could just correct one statement that Mr. Huff made on the record, that he did not know about the proceedings at the Attorney General's office. We served the motion for summary disposition on him via certified mail. I have a copy of the green card that he signed for. So he did have actual notice of the motion for summary disposition. It clearly states on the first page in bold 14-point type that he has 15 days to respond to it. That's a requirement under the SOA regulations that a respondent be on notice of the fact that they have 15 days to respond to a motion for summary disposition. I'm looking at the document. I believe it's in your backup as well. And I have the green card showing that he did receive the motion for summary disposition. He signed for it himself.
Are there any other questions, comments, discussion?
Commissioners, I think, just to recap, you've heard all the discussion from both the Attorney General's office on behalf of the Executive Director and also Mr. Huff here. I want to reiterate, again, if the proposal for decision, the facts are all have been accounted for and deemed as proven by the administrative law judge, the 3 instances of noncompliance with continuing education standards. We've discussed the mandatory nature of our rule that's been promulgated as it relates to continuing education, that 3 non-compliant instances of non-compliance is a mandatory revocation. We've discussed also the option, if you choose not to adopt the proposal for decision today, you can leave the record open, and Mr. Huff can provide whatever it is that hasn't been provided by him thus far, if you want to consider that. Or if you want to keep the revocation option open, he certainly can permanently surrender his license in lieu of revocation.
Questions about our options? Do we have a motion? I'm sorry.
Commissioner, his first instance of noncompliance with the continuing education requirements was in December of 2015. That was his first reprimand for noncompliance. His second was in April of 2018, and his third and final was February of this year. February of 2020, which then resulted in the institution of the revocation proceedings.
Do we have a motion?
Chair, I make a motion that we adopt the PFD and revoke the license of Mr. Hughes.
Would you elaborate on PFD, please? We have a motion and a second. All those in favor say aye. Aye. Any opposed, same sign. Carries.
Commissioners, the remaining items on your agenda are for information only and no action is required. There's one individual listed who agreed to a term surrender or implemented a term surrender of their peace officer license. And then there are also a number of individuals listed who have permanently surrendered their peace officer and jailer licenses. In addition, there are categories for administrative reprimands and reprimands for failure to comply with continuing education.
Questions or discussion? Thank you very much, sir. Thank you for being here.
To read all the reprimands into the record. He has come a long way.
Okay, we will move to agenda item number 10, which is discuss and take action on the project of the strategic plan. If necessary, we had the ability to meet yesterday to talk about the strategic plan and the progress made. I believe that the only change was really to some wording that Commissioner Burris brought forward. But I would like Director Grigsby, if you could, for the audience, just give a brief overview of the progress that staff and commissioners have made.
Yes, ma'am. So back in October, we met collectively in, I think, what was probably one of the first commission work sessions in quite some time, and we discussed the overall concept of strategic planning. Following that meeting, staff got together and took feedback from the commissioners and from our internal staff discussions and put together what we thought was an appropriate framework for the overall guiding principles of the agency as directed by the commissioners. And so the main components there include communication, decision-making, and innovation. And so there was one change that was made yesterday. It previously said data-driven decision-making, but I think per Commissioner Burris's recommendation, we have made that overall as decision-making instead of specific to data-driven decision-making, because data does, of course, influence all of those components there. And so those are the three overarching topics that the strategic plan framework outlays, and there are strategic goals within each of those. I don't know how much further discussion we want to get into that today, but those are the overall guiding principles that we have seen and implemented as an agency as we go forward.
Yes, and for the audience, the three areas are communication, decision-making, and innovation, and that's what the agency will be focusing on over this next year. We will be reporting out on the strategic plan each meeting. It will also be discussed in each of the workshop sessions. We believe that this is vitally important to the organization and should drive all of our actions and decisions moving forward. So we do not need to take action on it today unless any of the commissioners have a proposal to do so. So we'll move on to agenda item number 11, which is to discuss and take action on legislative items to include exceptional items and performance measures, data information provided by TCOLE staff, and updates from the TCOLE divisions if necessary.
Madam Chair, what 11 and 12, we were worried that yesterday might run over and would not have to finish today, so we put them on the agenda for today just in case we needed to come back to them. So they're there for if y'all have further action or discussion that you want to have on these items, we're prepared for it, but otherwise, I believe it was covered yesterday.
Looking at 11 and 12, would you please, for the audience, discuss 12, please?
Yes, ma'am, I'd be happy to. On the discussion held yesterday on appointment of licensee form to include the pay status, we have brought the recommendation up for discussion with the commissioners. The staff has that on the L1, which is the appointing document that chief administrators of an agency do when they actually appoint somebody to an agency, currently there are multiple pay statuses on there. There's full-time, part-time, reserve, and other. Those were items that were placed on there in the relatively recent past, just within the last few years, had a specific purpose at that time, but that purpose has not continued on, and it's actually causing a lot of confusion with those different those different pay status terms, especially the one reserve, because it gets mixed up with a reserve license. So our recommendation is to simplify the L1 form, and I believe in the discussion yesterday, I think where we, if I remember right, where we settled was to have instead of a pay status, have a full-time box and a not full-time box for an appointment. Since all appointments are full peace officers now, we don't issue any reserve licenses anymore. By simplifying that, it clarifies what those appointments actually are and kind of frees up a lot of that confusion, if that's a good synopsis of the discussion yesterday. And I believe that's where we landed when we left.
In relationship to agenda item number 11, I'll be working with the executive director and appointing a subcommittee to look at the exceptional items for number 12. We did direct staff to move forward with changing the L1 form to where it shows the two designations that the executive director just outlined. So any other discussion? We do not, since we took action yesterday, we don't have a need to take action today unless Any of the commissioners?
I'll say, just to clarify, we did not take action yesterday. We had discussion
Okay.
on the two items. So no action was taken yesterday. No action is being taken today. Had a longer discussion about each of these items.
Thank you for the clarification. Okay, we're going to move to agenda item number 13, which is discuss and take action on the process, procedure, and qualifications related to the selection of the next executive director. We did have a discussion yesterday and did talk through some of the qualifications that we would be looking for and expecting in an executive director. We did divide that into two sections. One would be a mandatory qualifications. The other was preferred, which is what we would like to see, but it wouldn't necessarily preclude you from moving forward in the process. And I know that we took some notes yesterday. I'm going to ask you, Mr. Beecham, if you could outline.
Oh, sure. Well, there was a, if you give me just a second, I'll get the timeline. I took a picture of it with
Sure.
my phone.
Sorry, I should have warned you.
That's okay. It's the time now.
Jeopardy, if you want me to.
While this phone warms up here, make sure everybody got a copy of this yesterday. It was sent out to all the commissioners, so you should have a picture of it. Let me pull it up here on my phone, and I'll... All right. Okay, the day being the 14th of April, the timeline, I was going to see if we were real lucky, it might have been left up there overnight, but we'll go off this. At the next commission meeting, which I have here on my notes in June 9th of this year, the goal set was for the commissioners to name, or if necessary, an interim executive director for all the upcoming dates throughout the fall and early winter, and also have the qualifications as formatted by a subcommittee between now and June 9th for final approval by the full commission, and for directions to staff to post at that point for 10 to 14 days as directed by the commission. Does anybody have any questions or any additions to that first point on the timeline? Sure, we can do that too. Let me grab my notes on that. Okay, we've got, these are Commissioner Burris's notes that I'm reading from, just so everyone knows here. Her handwriting is much better than mine. For the education and experience, minimum qualifications, eligible to be approved as a Texas peace officer, 8 years law enforcement experience, bachelor's degree from accredited university, or 15 years full-time law enforcement experience with 5 years of command level experience, budgetary experience, effective written and oral communication, and that's just minimum standards to emphasize that those are the minimum standards. Does anybody have anything to add or any questions about the minimum standards that were just read?
This was our first discussion as a commission, starting to figure out, what are we looking for? What are some of the minimum standards? After that, kind of what are some of the preferred things that we're looking for? This is not a final by any means. This is just our first thoughts in the couple hours we had to talk about it yesterday as a group. So this is not set in stone, but kind of what we were thinking as of yesterday.
for preferred qualifications, advanced leadership training from the FBI National Academy or comparable professional training, leadership training.
I want to circle back and clarify on something as far as the eligible to be appointed as a Texas peace officer. First, is that where we? I think I think we might need to have some, and maybe that's in the subcommittee work that comes back to the commission with that on eligible when, right? Is it, one, eligible within a year? If we're talking about being all encompassing and casting a wide net, if you will, flushed out on that eligibility.
Okay, we will be working with a subcommittee over the next 2 months before we come back together again in June. The goal is to present a draft, finalized job description to the entire commission for discussion. Beecham noted the other goal is to come back at the commission meeting in June and vote to accept the job description and potentially give TCOLE staff marching orders to move forward to posting. That in June, the members of that subcommittee will be Atkins, Hester, Burris, and Lameau. So we will move on to agenda item number 14, which is receiving public comment on any topic without action. And we do have a card from Brett Batchelor. Yes, ma'am. Sir, if you'd come up and introduce yourself.
Morning, Commission. My name is Brett Batchelor. I'm the training coordinator of the North Central Texas Emergency Communications District. I just want to say I appreciate y'all allowing me to come speak with you today. Our region, NCT 911, we cover 13 counties, 40 PSAPs, over 600 telecommunicators. Excuse me, I'm a little nervous this morning. So I'm really excited to talk to you today, especially of all weeks, TC Appreciation Week, so it's very special to be able to speak with y'all today here. With me today is Chris Briggs, Deputy Director of the Parker County Hospital District, EMS. And what I'm here to speak with you today about is House Bill 786, telecommunicator CPR, and just tell you kind of what's going on. So as we talked about telecommunicator CPR, the two requirement that came in place, before we kind of go into that, I'd like to really briefly explain for anyone that's not aware how EMS, medical procedure, and CPR calls are handled currently in the state of Texas. So when you call 911, this has happened before this law was enacted. This is just how Texas works. So when you call 911, you're going to go to one of two type of PSAPs. You're going to go to PSAP where I answer the phone, 911, I get the information. I'm going to be EMD certified. I'm going to give you all pre-arrival medical information on the phone with you at that time. CPR, whatever other medical information you need in that emergency. That's point one. The other one is going to be, I'm going to call and I'm not EMD certified. Maybe I'm a smaller agency, my agency doesn't pay or have that, and what I would do is that agency contracts out to a secondary PSAP, like Parker County Hospital District. I get the information, the address, confirm it, and then I transfer it to that higher level of care so they can give pre-arrival instructions, medical, CPR, and all that to our citizens. So currently in the state of Texas, you call 911, you're getting medical, pre-arrival, and CPR. So we have this new law that came into effect, House Bill 786, requiring telecommunicators to get CPR training. So this is a little bit redundant. Telecommunicators and statistics have that. Or if they don't, there's a mechanism in place for it to be handled there. So the problem therein lies requiring the whole state of telecommunicators to have this procedure. So my agency doesn't handle that. It's not my policy and procedures. It's not my guidelines. But now I have this training. The person calls, they need help. Do I provide CPR to them? If I do, obviously I'm outside of my agency's guidelines, procedures. Things go good or wrong, that's liability falling on me, not on the agency. The expectation of the public is now that every person they call, the first person they talk to is going to be giving them that CPR instruction. Why aren't you going me? Hold on, sir, I'm going to have to transfer you to that secondary PSAP because even though I have the training, I'm not going to go outside my policies and procedures of my agency. So it's a really, it creates a huge liability issue. If I did decide, even though it's outside my agency's guidelines, I know CPR, I'm for sure this is a CPR call, and I'm going to handle it. I get down the road, I realize it's not, now I've delayed care. We've wasted the citizens' time and put them in greater jeopardy, and now I'm handing a worse situation off to my secondary PSAP, the person I'm transferring for medical assistance. So this legislation that came out really, I think, just put, with all good intentions, we need to get everybody CPR trained. This is something we need to do, provide this for our citizens. This isn't something extra. This is a duty we have to provide this. It's so important, but this is something that we're already currently providing. So by adding this in, it really puts a difficult spin for TCOLE, for telecommunicators, for the whole state is how we need to manage this. So the first thing I think is we need to get together, go back to the legislative session, explain this to them, and see about modifying it. There's a lot of states that have had these legislations put out, specifically Minnesota also had one as well. They modified the legislation to list telecommunicators have to have CPR training by that agency, or they can choose option B, which would be we will transfer to that secondary PSAP so they have CPR training. Because now we're requiring a certification for our telecommunicators that they're not going to be able to use. Or if they did use it correctly, while you're doing CPR, you break that person's ribs, the agency's going to say, well, that's not in our policy and procedures. You shouldn't have done that. You're going to have to basically take those consequences of that. So when telecommunicators, we figured out what was going on, TCOLE started working on this. The Texas 911 Trainers Association, TNT, has worked with TCOLE in the past, creating curriculum, building things. You can go on TCOLE online, see TNT authored classes, because TCOLE realized, you know what, if we're writing telecommunicator courses, we need to get subject matter experts, and has used TNT in the past. And TNT has been working with TCOLE on trying to figure out how to make this course the best course for our citizens to be able to meet the needs of our public. We worked on a lot of different things, trying to identify some issues. However, as we continue down the process, our concerns regarding the curriculum that's currently out were not addressed. And now the curriculum we have, again, with great intention, creates a lot of issues for us. Specifically, the occupation code has changed. The TCOLE will not license a telecommunicator unless they have the 1080 basic and you have the TCPR course. The course curriculum for the course we just listed says that you cannot take this course until you're licensed. So you can't do both. There's an issue there. So there's just some things I would like to go back to legislature, bring these issues to their concern, continue to work with TCOLE on this curriculum so we can get the best product for our citizens. And to kind of talk about the medical aspect, I've got the Deputy Director, Chris, here to kind of share his thoughts as well.
I think you did a great job of speaking about our concerns. So part of my job, real quick background, been a paramedic for 20 years, EMS, Deputy Director of EMS. and I run a training site for American Heart Association. So I train instructors to teach CPR. The way it's currently written, I'm not even qualified to teach telecommunicator CPR because I've not been a telecommunicator for 4 years. So that's one of my concerns. Another thing is I've heard people say there's no additional cost in agencies. CPR is not free. I work in Parker County, population of 150,000. We have 16 fire departments. None of them teach CPR that I'm aware of. So for even me to teach a class to my staff, there's a cost associated. There's a cost for books. There's a cost for cards. Who's going to eat this cost? Like, you can't, CPR course is not as simple as running to your local fire department and saying, hey, teach me CPR. In fact, we have to set up a class. I can only teach 10 people max per instructor. So if we're doing, he said 600, that's a lot of classes. And that's a lot of money for payroll for me and, for the students. So another issue, referring to the instructor resource guide for 786, for the instructor prereqs, you say in there that current and valid CPR trainer certification from a nationally accredited program. That doesn't exist. There is no nationally accredited CPR course. So we need to look into that. I know you say that this includes but not limited to American Heart and American Red Cross. Those are very well recognized courses, probably the two most in the country. But the way CPR works, it's up to the agency to decide what they're going to recognize. But there is not an organization that accredits a class or course nationally. So I just want to take that into consideration. That needs to be reworded. And we also speak about saying that we can only do in-person CPR. The American Heart offers a hybrid course where you do an online version for 2 hours, and then you have to do a skills check that's in person that covers what you list. That should be accepted. If it's good enough for American Heart, which is, I would say, the gold standard in CPR, that needs to be accepted. And if it is accepted, it needs to be clarified, I think, in the document. So I think those are things I'm happy to help in any way I can, answer any questions if you got any for me.
Do the commissioners have any questions of staff?
Are you taking notes?
Just to kind of clarify, I don't believe any of us have ever said that there would not be a cost involved with implementation. We realize that CPR from either of the two providers listed, the language we use for national accreditation, most people would see American Red Cross, American Heart Association as nationally recognized. So I think we're stumbling over the word accreditation.
Well, sorry.
We can certainly modify that, to make the language more acceptable. We did involve subject matter experts to include members of TNT in the original focus group and help work on the curriculum. So they did produce a document, and we did review it. We went with the subject matter experts. Some of the changes recommended were made. Some were discounted, I guess, by the group we had assembled. And we can do some clarification because and Gretchen, correct me if I'm wrong, when we talked to the author's office, it was the demonstrative, he wants these people to know CPR and to demonstrate the skills. Now, the course he's listing, which is a blended learning event, part of it's online, but you have to do the skills portion. For our purposes, that would meet the qualification for the CPR course. So that's certainly an acceptable option.
No.
No, just get clarified.
Yeah, to make sure that, I think we, probably at that point, we started getting into discussion, and then we're getting something that should be an agenda item. If we kind of get it back and forth like this, but it's certainly a follow-up question to staff is permissible, but I think we've went as far as we possibly can with public comment.
So thank you very much, gentlemen.
Okay, thank you for
We
your time.
appreciate you being here and appreciate your comments.
Thank you. We appreciate it very much.
We have agenda item number 15, which is executive session. We will be going into executive session. Do we need to take a break a quick break first? Okay. We'll go into executive session at